The thing is that
Mm-hmm.
this is the only feedback I've been getting everywhere. Like constantly same feedback that cut short your answers, or else you might get reduced marks. That's why it's actually making me anxious now how to cut short my answers. I'm saying that, as you rightly pointed out, my flow is because I give long answers and I try to include everything in it. Ma'am, I used to regularly follow the YouTube lectures, the YouTube videos, the editorial discussion, and others also, especially for prelims.
Good afternoon, all. So please introduce yourself.
My name is Anmol Rathore. I come from Bhadra in district Doda of Jammu and Kashmir. I've done my BA LLB honors from Gujarat National Law University. I completed my graduation in 2021. I recently qualified the Jammu and Kashmir Civil Services examination, and I'm currently undergoing training for the same. And my hobbies include writing English free verse poetry and chronicling the life experiences of elderly people. That's
Or
about me.
Anmol, just answer one before I go into the actual interview. I find that from your DAF, you have blacked out your date of birth, your father's income. Some of the information will be blacked out. Why?
Certain personally identifiable information regarding me and my parents, including their incomes, I black those out, just keeping in mind certain concerns about privacy. Because I was told that certain information does get shared with other institutions also. So I was quite wary of the same. That's why.
Okay. I can understand your email, your contact numbers, etc. But your date of birth is important.
Yes, sir. I'm sorry. I'll let you know. My date of birth is 3rd June 1999.
3rd June 1999.
Yes, sir.
So you are not 24 or 23 and a half or whatever.
Yes, sir.
No, she's 24 and a half.
Yes.
And this is your third attempt. Okay.
Yes.
All right. Now, Anmol, you are a law graduate.
Yes,
Hmm?
sir. Yes, sir.
What is the area of the law that you are studying?
Sir, in the undergraduate course, we were taught all the areas of law.
So you are familiar with the international law.
Yes, sir.
There is a case these days being prosecuted in the International Court of Justice.
Yes, sir.
Which case?
Sir, this is a case which was instituted by South Africa against Israel relating to the acts of genocide in Palestine by Israel.
But that was a case instituted by South Africa a long time ago, maybe around a month ago, isn't it so?
Yes, sir.
So is this a new case or what is this case about now?
Sir, this case was instituted in the last month. This was about the presumed acts of genocide being committed by Israeli forces in Gaza.
And
However,
what was the outcome?
so currently ICJ has provided for provisional measures, which are sort of interim measures, whereby it has directed the Israeli forces and the government agencies to ensure that no acts of genocide are committed in Gaza. Secondly, it has also asked Israeli government to ensure there is no incitement for violence against the civilian population. And it has also asked Israel to not destroy the evidence which is present there. And
I'm talking about the present case. There is a present case in ICJ which is being heard.
Sir, in my limited knowledge, it might be the case against Israel regarding the occupation of Palestine. That is another case.
Okay. Now, in these cases, when ICJ has given a verdict, according to law, how do you enforce those verdicts?
So the verdict of ICJ is legally binding on the parties before it under the statute of ICJ. However, if a party does not enforce the decision, the other party has the recourse to approach the United Nations Security Council under Article 94 of the UN Charter. It can ask the United Nations Security Council to enforce the decision or to take certain measures. However, again, given the fact that we follow the principle of sovereign equality of all states, a state cannot be compelled otherwise to follow a decision.
But a state party to the dispute or to the decision can go to the UNSC for enforcement of the decision.
Yes, sir. Indeed, it can.
So in this case, if ICJ does not agree to vacate occupation of Gaza, can South Africa can go to the Security Council?
Sir, since the case by South Africa is regarding the Convention on Genocide, it is not about occupation. The case on occupation is a separate one. So, but in case Israel does not abide by the decision, South Africa or any other country can ask the Security Council to enforce it.
And if UN Security Council gives a decision under its own enforcement provisions, and since you are a student of law, you know there is a Chapter 7 there. So if UN Security Council gives a decision, then that becomes binding on all the members.
It does, sir.
So what do you think of it? Then that means Israel will be bound by the Security Council to basically stop the acts of genocide.
Yes, sir, it will be.
All right, thank you. One last question. Article 370
Yes,
in
sir.
Kashmir, it has been abrogated and not yet abrogated legally. What does it mean?
The Article 370 is still very much a part of the Constitution. However, its effect has been curtailed because now, as per Article 70, which is amended, the entire Constitution of India shall apply to Jammu and Kashmir. So it is still a part of the Constitution, but its effect has largely been curtailed as it was previously.
How was it done? If it is still part of the Constitution, but effect has been curtailed, how?
Sir, so it was firstly, the Honorable President issued Presidential Order 272, whereby the Article 367 was amended to read that the term Constituent Assembly in Article 370 shall be read to be State Legislative Assembly. And thereafter, by Presidential Order 273, it was provided that the President can now, the President now amends Article 370, and it shall now read as all the provisions of Constitution shall from now on apply to Jammu and Kashmir. So that is how it is.
So that was clever, is it?
Yeah.
All
Yes,
right.
sir.
Thank you very much.
Thank you, sir.
Sanjay.
Anmol, good morning to you.
Good morning, sir.
What are three judges' case?
Sir, the three judges' case are a part of the series of cases which establish and clarify the rules on the collegium system on the appointments of judges to the Supreme Court and the High Court. As per the three judges' case, the recommendations of the collegium to the recommendations of the collegium to the recommendations of the collegium shall be taken into consideration by the Honorable President for appointment to the Supreme Court. And in three judges' case, the National Judicial Appointment Commission, which was established by the 99th Constitutional Amendment, was struck down because it violated Article 51 of the Constitution, which provides for the independence of judiciary.
All right. So there is a primacy of the collegium.
Yes, sir.
Collegium comprises how many Supreme Court judges?
So for appointment to the Supreme Court, it comprises the Chief Justice of India and two senior-most judges. However, the collegium differs for appointment to the High Court and the transfer of judges.
No, collegium for the Supreme Court.
So as far as I remember, it comprises the Honorable Chief Justice of India and two senior-most judges.
No, four senior-most judges.
All right, sir. I'm sorry.
That was the 90th. There are 3 judges' cases. In the second judge's case, which year was it?
So, if I remember correctly, it was 1999, perhaps.
And that was the third judge's case,
All
in
right,
which
sir.
it was increased to 5. This collegium now comprises Supreme Court, Chief Justice, and 4 senior most judges, total 5. All right. NJAC was this primacy of NJAC was amended, right?
Yes.
In your opinion, should the Supreme Court have the final authority of selecting judges for the Supreme Courts and High Courts?
Right, sir. So it is a very valid concern that the Honorable Supreme Court should have a say in the appointment of judges, because
Final
only
say, I said, say is all right, but the final say, you are a law student.
Yes, sir. Sir, if we look at the Constituent Assembly debates and the position which was held by Honorable Member Dr. B.R. Ambedkar, even he said that the primacy of judiciary is not what we are aiming at. And if we also look at Honorable Justice Chalameshwar's dissenting opinion, he also distinguished between the primacy of judiciary and independence of judiciary.
I
Therefore,
asked about your opinion.
so my opinion is also based on the opinion of these legal luminaries that primacy of judiciary should not be equated to independence of judiciary, and we can bypass primacy of judiciary in appointments.
Very good. Tell me, you're a law student again. What is AFSPA?
So AFSPA refers to the Armed Forces Special Powers Act. It is currently applicable to certain parts of India, including certain northeastern states and parts of
what special powers are given to armed forces, Central Armed Forces?
So first would be the power of search and seizure without a warrant. The second includes the power to apprehend a person who is suspected to be a terrorist or who might be carrying out an armed activity against the state. And in case the person does not heed to the directions by the armed forces, even death can be caused in certain areas. And all of these powers are applicable in those areas which are declared to be disturbed areas by the central government or state
Very
government.
good, very good. Terrorism has relatively increased in Jammu recently. What can be the reason in your estimate?
So, although the traditional sense in which we understand terrorism, it has certainly decreased in J&K after the abrogation of 370. We see a resurgence of terrorism south of Pir Panjal, especially in Poonch, Rajouri, and certain parts of Jammu. There could be several reasons. The first one that comes to my mind is that there is now increased security deployment in Kashmir, which used to be the hotspot of terrorism. And this has led to concomitant reduced deployment in Poonch, Rajouri areas. Secondly, during the Ladakh, China's incursion in Ladakh, several security forces were shifted to Ladakh from Poonch, Rajouri region. That also aided the influx of terrorists. And thirdly, these areas of Poonch and Rajouri, these are bordering areas and borders are not completely fenced here. We see there are dense forests in Pir Panjal range, and the terrorists are very much familiar with these areas. And there are also existence of certain natural caves and hideouts. And these provide these terrorists with ample positions to hide, and the use of technology
So why
using satellite.
increase now? The third, I'm talking about the third reason. Why increase now?
So increase now could be because they are not able to carry out proper terrorist attacks in Kashmir. So their focus is now shifting to these areas. And also the fact that post abrogation of 370, there has been development in Jammu and Kashmir, which is certainly an issue for our cross-border neighbors.
All right, all right. Thank you.
Thank you, sir.
Sorry, Achalji. You will have to unmute yourself.
Can you hear me?
Yes, sir.
Good afternoon, Anmol, and congratulations that you have already qualified the J&K Civil Services exam. I'm sure
Thank you.
looking forward to coming into the center. So let me begin with a couple of things which have, where I want to be educated by you, being an expert in these fields. Recently there was a Supreme Court judgment which pertains to the funding of political parties by the corporate sector. What is this judgment about, and what do you think? Will it have a positive impact, or will the government accept it, or is there a possibility to, uh, not comply with what Supreme Court has, ruled? So overall, how do you look at it?
Right. So recently, the Honorable Supreme Court in ADR versus Union of India struck down the electoral bond scheme because, as per the five-judge bench, it violated the right of information of voters regarding the funding of political parties. Now, in my humble opinion, this decision is laudable because it seeks to balance the right of informational privacy of donors with the right to information of voters. And this will certainly go a step further in ensuring that we have free and fair elections in India. So basically, what the Honorable Supreme Court held was that any donation which is above rupees 20,000 and it is anonymous and it is by a corporate donor, that is not essentially done because these corporate donors have their own political interests. Rather, it is done to secure quid pro quo. And this provides them a seat at the policy making table, which might not be in the interest of the general public at large. And therefore, all of this information needs to be divulged to the public so that they know which party gets how much donation from which corporate sector. And in my humble opinion, this is certainly a right step. The executive and the parliament will have to abide by this judgment because this is a power of the Honorable Supreme Court under Article 13, the power of judicial review. And this constitutional power has been utilized very well by the Honorable Supreme Court. And in my
Okay,
opinion,
but part two of my question: how will it impact? Don't you think the funding to opposition parties, once there is a transparency, once it's in public domain that who's funding whom, the donations to opposition parties will dry completely, or to some extent. So will it be fair?
yes, certainly these are certain apprehensions which exist. However, as the Honorable Supreme Court has also pointed out, the right of voters to be informed of the political fundings that reigns
No, I
supreme.
agree. I agree. I mean, the rationale, Supreme Court's rationale, transparency, all that is acceptable. I'm asking about the impact. And that takes me to a larger question of funding of the electoral processes. Do you agree that state should fund the elections, or do you think there is a other way whereby the transparent manner we can hold elections at the national level, regional level? Essentially,
Right.
state funding, the question of state funding.
So, in my limited knowledge, we do have certain provisions of indirect state funding of elections in India, such as giving tax exemptions to political parties or free airtime to political parties during electoral campaigns. However, providing a blanket access to state funding will certainly have a detrimental impact on the state exchequer. And given the fact that we have certain other uh, issues that we need to deal with regarding the financing of our country, I do not think that a complete state funding is viable. And this has also been observed by the National Commission to review the working of the Constitution in 2002, that state funding is not a feasible option in India because we have many regional parties, many unregistered parties. So state funding of all of those parties might not be a very feasible and economically viable option. However,
Okay,
we can
suppose we adopt a different way. We have a corporate funding, and all the funds go to election commission, and then those funds are distributed to political parties, maybe based on their performance. Do you think this is a feasible way of handling this issue?
This is also a viable practice, and a type of this practice was also adopted in Chile. However, here again we see there might be an issue that the corporates might already divulge this information to the political parties that we are donating so and so amount through the Election Commission of India. So here again these issues do crop up, and the
No, but
Chilean.
then how will it matter? Everything will go to the Election Commission of India, and Election Commission of India will distribute. That should not be. But do you think the corporate sector would be happy to donate it to a body which is conducting the election, but not a political party, which may, be obliged to then quid pro quo, about which the Supreme Court has talked about?
So, in my opinion, in the interest of transparency and free and fair election, this could be a feasible option. And additionally, we could also go for electoral trusts, which are already in existence. So these are a few mechanisms which would help us, because electoral trusts also ensure that there is transparency in electoral funding. And if such money is given to the ECI, that will also be a viable option, because we ensure transparency and an independent constitutional body is the mediator in funding. So in my opinion, that could be a feasible mechanism.
Okay. I think thank you, Anmol, and over to you, Chair, sir.
Thank you very much, Mr. Malhotra. Thank you. All right. Anmol, can you please just step into the waiting room for a few minutes? We'll call you back for that.
Yes.
Gautam can help you out. Yeah. Right. Okay. Okay, Anmol, good to have you back. Now, when is your interview scheduled?
14th March.
For 14th of March. You have less than 3 weeks, but plenty of time, really. And how many mocks have you done?
So I've given 5 mocks.
Offline, online, or what?
So 3 offline, 2 online, and
Okay.
this would be the 6th one.
The 6th one. And where you Delhi for the offline? Where did you do offline interviews?
Yes, sir, I'd come to Delhi for my offline mocks.
Okay. And what was the feedback in the previous mocks?
So the first feedback was that I talk very fast and that I give very long answers.
Um,
So you have not improved.
We also noticed.
and what else?
I've been trying to curtail, but I just can't. This is a repetitive feedback. Apart from that, I was told that I have a pleasant personality, but the 2 areas that I need to work on is speak slowly and work on my speaking speed, talk less, and not give out a lot of information. And also that I need to brush up on my current affairs.
Okay. I think they have told you exactly what we had in mind. What is that you do tend to really give very, very long answers. Now, the problem with the long answers is, I think they must have also told you, it will limit the number of questions that the board members can ask you. And that's the only way for them to find out about you really. So you are limiting your opportunities for getting selected by giving long answer. Now, I think there are 2 or 3, I'll come to that in a moment. Speak slowly. I think your speed was fine. You can speak slowly, sound more measured and more kind of balanced in what you're saying. That's fine. I think what is happening, Anmol, is that being a law student, where you're supposed to give different views, the left, right, and all those things, so you tend to basically give a more comprehensive and more complete answer on any issue than staying on the point. So I think it would be useful if you really focus on the need to stay to the point rather than going on the peripheries and everything. And to do that, really what you should do is that before you begin to answer the question, take a pause, focus your mind on the question, and then answer the question. Try that, okay? And see how you can achieve it, number one. Number two, you tend to give far too much information when you are answering very detailed. And sometimes there is a danger, there is a very serious risk of some of that information, if not all, some of that information being wrong or unnecessary to hey, but even being incorrect. For example, in the case of the Supreme Court decision on electoral bonds, are you sure the Supreme Court said that the corporate entities are trying to seek a place at the high table, political high table? Are you sure about that?
Yes, sir. I'm not. I think I read it in an editorial, and maybe that is why I missed.
Different thing. You cannot quote an editorial in terms of supporting a decision.
Yes, sir.
So that's what I mean. You gave information, and somebody could question you on that.
Right, sir.
No Supreme Court decision can mention political high table. That would be prejudiced. Okay? So if you simply said that right to information, under the right to information, any kind of funding for a political purpose should be transparent. That's it. This is what they said. Okay? So pause, think, answer. Important. Security. I talked about Security Council, Gaza issue. छोटी सी चीज कहनी थी आपको कि in the United Security Council, even if South Africa goes, United States will veto the resolution. And you are a student of law, you know how the Security Council functions. Simple. But you didn't do that only because you are thinking of all kinds of things. So that is what I would suggest. From now on, please, in your mind, train your mind to pause. Control what you are saying. As a lawyer, words are important. Control, measure. All right. I think that's really, I can't think of anything else, but if you have anything to ask, please go ahead.
So I just had this apprehension that if I will speak less or give less points, they might think I lack knowledge on the issue. That is why I tried to give a comprehensive picture.
I think we have already answered that question. There is no danger of the thinking that you know less or anything at all. In fact, there is a danger of the thinking that you are trying to hide something that under the longish verbose answer. A good answer is always sharp to the point.
All right, sir. I'll work on this. Sure.
You must, because you are most likely going to be selected. So therefore, we are hoping that you will not mess it up by being too loquacious.
All right, sir.
Okay. So we hope to see you the services next year or this year, but beware of that. Okay. All the best to you then.
Thank you, sir. Thank you so much.